Appreciate you putting this together. We've got our recording message now, so we're good to go. So we're going to have a lot of information because there's been a lot of new stuff that's come out from the courts over the last couple of months pertaining to leasing issues, and so this will be a good beneficial one for a lot of people who are either doing commercial leasing on the tenant side or commercial leasing on the landlord side. Either one of those will benefit from listening to today's discussion. So today's discussion will be about the new legal issues that you need to account for in your commercial leases. But before I dig in there, I do want to introduce myself really quickly. My name is Patrick McQueen. I'm a real estate attorney here in Arizona. I've been doing this for about 20 years. Our firm handles all sorts of real estate litigation and all sorts of real estate transaction matters, including the stuff we're going to talk about. Before I get into the leasing issues, I do want to talk about a couple of other issues that have popped up that pertain to you and your practice and your clients, particularly investor clients. The first one pertains to short-term rentals, and right now we're getting quite a lot of questions about new short-term rental laws. We just had a new statute. Today is September 27th, 2022. We just had a new statute go into place 3 days ago pertaining to short-term rentals, and this will have a big effect on, like I said, on your investor clients. Cities and towns and municipalities that have largely been hamstrung by state laws now have the ability to regulate short-term rentals or get in the game and require licenses. And so if you are helping out a buyer, or if you're helping out any other investor with short-term rentals, you really need to know that we have these new laws. They went into effect 3 days ago. If you need a copy of the new statute, just let me know, but just something to keep in mind. We also now have an Arizona Supreme Court decision called the Callaway case, K-A-L-W-A-Y. If you need a copy of that, I'm happy to send that to you as well. But that decision came down from the Arizona Supreme Court. That one affects short-term rentals within HOA communities. And that decision basically amounts to a limitation on homeowners associations from being able to limit or restrict short-term rentals as well. So we have new state-imposed laws from our government, from our local municipalities, from the cities and towns, and that went into effect 3 days ago. And then we have a new law called the Callaway case, which will affect short-term rentals associated with HOAs or short-term rentals in HOAs. So two very big and potentially confusing sets of laws because they kind of seem to conflict. And so if you need guidance on any of those, I'm happy to send you those. Another big new law that came into effect at the early part of the summer were these new wholesaling laws. And so some of you may represent wholesalers, whether on the residential or commercial side. In connection with a wholesale transaction, the wholesaler, the person who is assigning the contract, must now disclose that they are a wholesaler. And so they have to make the disclosure to their seller, the person that they're buying from, that they are a wholesaler and may be assigning the contract to make a profit. And usually the sellers that they're purchasing from are distressed sellers. And so you've got to now make a disclosure. And you also have to make a disclosure to your end user, to your buyer, that says, hey, I'm a wholesaler here. I may not actually have title to this property. I'm not purchasing title. I'm assigning this contract. And so it's a pretty significant disclosure requirement. It will cost you the deal. It will cost you somebody's earnest money, perhaps. And so just keep those in mind if you're representing a wholesaler, or if you're doing any wholesaling or investing yourself like that. The third call that we've been getting quite a lot of recently, particularly on the commercial side, involves enforcing commercial transactions or enforcing commercial contracts. Okay, so for purchase and sale agreements, well, I'm going to talk quickly about the remedies that a seller has in connection with a commercial purchase and sale agreement. The seller typically has two options if the buyer is in breach. If the buyer is refusing to close after their inspection period, if the buyer is refusing to perform, the seller typically has two remedies in that situation. The first is they can keep the earnest money. The second is they can say, I don't even want the earnest money. I'm going to sue for damages because now I have to go out and sell this piece of property for much less than our contract, than the original contract. So again, In the commercial setting, if you're dealing with a commercial purchase and sale agreement and you're representing the seller, you can remind them that they largely have two options available to them if the buyer is in breach. Those options are keep the earnest money, or number two, waive the earnest money and sue for damages. Now, you can include in commercial deals even more remedies than people traditionally have. And you can ask for specific performance, you can ask for a number of other things, but you have to make sure that those are in your contract. Okay, so again, we're talking about the remedies if you're representing a seller in a commercial real estate transaction gone bad. Okay, if you're representing a buyer, you also have largely two options. Number one, you can sue for damages, or number two, you can seek specific performance, which is a court order that the seller sell the property to you. Now, obviously, you may have to give a cure notice, you may have to follow the mediation and arbitration and the alternative dispute resolution provisions in most cases, but keep that in mind. Usually you're going to have two remedies, whether you're on the seller side or on the buyer side, if a commercial real estate transaction goes bad. Okay, so again, what we're talking about now are some of the calls that we're getting, calls that we're receiving, you know, just to kind of give you an update. The first is on those new short-term rental laws that I went over. There's a new statute in place. It went into effect 3 days ago. We have a new Arizona case in place that went into effect in April, I think it was. We have new wholesale laws that went into effect recently. And then again, we're getting a lot of calls on enforcing commercial real estate contracts. Oh, by the way, for commercial leases, the way you enforce those is first you have to look at the contract. If you're representing the landlord, you got to review the contract. You may, in a commercial leasing situation, you may actually be able to lock out the tenant immediately. You may not need to give notice to your tenant. Now, that's a little bit of a risky proposition, but that is one of the remedies that you as a landlord or landlord's representative have here in Arizona. But you've got to look at the contract to see if there's a notice and cure right that the tenant has. Usually it's not a great idea to jump to that, but sometimes you may have to do that. So that's one of the remedies. If you're representing a landlord in connection with a commercial lease. If you're representing a tenant in connection with a commercial lease, again, we have to review the lease to see what remedies that tenant may have, what notice that the tenant has to provide. And remember, the lease may provide some rights, but unlike the Arizona Residential Landlord-Tenant Act, we're talking about commercial leases now. The Arizona Residential Landlord-Tenant Act does not apply in these situations. And so much different set of remedies, much different scope of things that you can do. So you really have to look to the lease in a commercial setting. Okay, so those are what we're getting a lot of calls on. I wanted to spend a few minutes to kind of remind you and to tell you kind of what we're seeing out there, particularly for investors, particularly for those in the commercial setting. Okay, again, short-term rental laws, new wholesale laws, and then we talked about remedies. People are asking about their remedies in commercial situations. Now, let's talk about some of the important updates that we've seen in connection with commercial leasing. Okay, and most of these updates are coming from our courts, and that's either we get our laws from two sources here in Arizona. We get them from courts, and they provide case precedent, and we get our laws from the legislature. And so most of these are going to be coming from the courts when we're talking about commercial leases. And these are things that you now ought to consider negotiating or including in your next lease. Okay, if you're representing a landlord or a tenant, you need to know about these 15 things or 5 things, or whatever the most important takeaway is for you. I'll kind of give you my top 10 or so. And I have checklists and sort of memos on all of these issues. In case you ever need those, I'll put my contact information in the chat and we can get those to you. But the first thing that usually comes to mind now, particularly after what we went through a few years ago, are force majeure clauses. Okay, force majeure refers to an act of God. It's Latin for an act of God or something unpredictable. And so what landlords and tenants are now doing is very much negotiating force majeure provisions. And what we have now are courts that are interpreting force majeure provisions. And we finally, after a couple of years of the pandemic stuff, are getting these decisions from the courts. And the courts are basically saying, we're going to interpret these provisions as you wrote them. We're not going to interpret them in favor of the landlords. We're not going to interpret them in favor of the tenants. And so what that means to me, when I'm drafting a commercial lease, or when I'm giving some suggestions on what should be included in a commercial lease, you've now got an obligation to be very explicit as to what you're including when it comes to the force majeure provision. Okay. What you should identify in the force majeure provision in any lease are the acts, the situations that cause an event of force majeure. So these are the acts that constitute an event of force majeure. If I can't get supplies, if the power is shut off, if I have to shut down my building, if there's a government shutdown, whatever it is, these are the acts that constitutes an event of force majeure. So courts want to see you being very specific as to what events can constitute an event of force majeure. Okay. The second thing that courts want to see, particularly now after they've made a number of rulings on force majeure clauses, is the notice provision. Okay. So this is the type of notice that you have to give either to the landlord or to the tenant if there is an event of force majeure. This needs to be in your lease as well. So we're identifying the event, the act of force majeure, the event of force majeure, and then we're also identifying how one of the parties, usually a tenant, will provide notice to the landlord that they believe an act has occurred. So we talked about acts and notice, okay? So what we're really identifying here is what happens if one of the parties believes or thinks that an event of force majeure has happened. So we're identifying what's happened, we're providing notice, and then we need to spell out the process. So if the landlord agrees that an event of force majeure is happening, what happens next? What are we doing here, right? We need to spell out the relief. Is it rent abatement? Is there no relief provided? Do we offer the tenant the right to terminate the lease? And so we need to identify all of these things. Again, we're talking about the act or the event. We're talking about the type of notice. All of this has to be in your new lease. And we're talking about the specific relief that will be granted. Again, sometimes that's a rent abatement. Sometimes that's nothing. It's kind of a wait and see. Sometimes that allows the tenant to get out of the lease entirely. Okay, so we want to spell out all of this stuff. We also want to spell out how long this relief will last. Is it going to be 2 weeks? Is it going to be 1 week? Is it going to be for so long as the event of force majeure is continuing? We just need to identify this stuff and put them in the lease. And courts will interpret these as written, as the parties intended. So it's very, very important to include this stuff now, because courts will grant this type of relief or they won't grant this type of relief, depending on what's in the lease, depending on what the parties negotiated and wanted. Okay, so that's probably one of the more important things that's come out of the last 2 or 3 years when it comes to commercial leases. Courts will interpret these as written. They're not going to invent a force majeure clause. They're not going to invent force majeure notice provisions. They're not going to invent any of that stuff. If you need a sample force majeure provision, feel free to ask me for one when we're done today. Like I said, I'll put my information in the chat, because it's very important whether you're representing the landlord or the tenant. Those are certainly going to differ in terms of the language that you use. Okay. Second thing that's come up over the last couple of years, particularly over the last 5-6 months in connection with commercial leases, is the use provision. Okay. What the use provision is usually identified pretty early. The use rights that the tenant has is usually identified pretty early on in the lease, and it'll just say, tenant's uses. And then it'll kind of give a general description, general office use, or medical facility to handle these types of things, or a restaurant for this type of restaurant. And the use provision identifies what you can do with this lease space. Okay. If you're a landlord, you very much want to limit this provision. You may be offering an exclusive use to some other tenant, and so you don't want there to be any mixed or duplicative uses within your shopping center or the area that you're leasing. And so if you're a landlord, you very much want to limit the use provision. You also want to limit the tenant's ability to change the uses or its use, because you don't want to affect the tenant mixture at any given time. Okay, so limiting the use is important for the landlord. So this is something that is going to be negotiated. If you're a tenant, you want this to be as broad as possible, because in case you need to change your use, in case you need to change the type of your business, in case you want to sublease or assign the space that you're in, you need it to be as broad as possible so that you know, you can use the space as you need to, and that you're not, you know, eventually falling in default. Okay. And so courts will look at the intent of the parties on this issue as well. So we've had some recent cases that have come down that basically say, you know, I as the judge am not going to interpret this any other way than as is written. So you need to be very specific as to what can be used and what really that use constitutes. Okay, is this a small office? Is this a big office? Can it be used for clerical stuff? Can it be used for medical stuff? And so we want to narrow in, if you're a landlord, on what those things are, and we want to broaden it as much as possible if we're a tenant, for a number of reasons. We went over those reasons. Okay, so we've talked about force majeure clause. We've talked about the use provision, both of which have now been addressed by the courts. Let's talk about subordination, non-disturbance, and attornment agreements, or SNDAs or NDAs. Okay, so a lot of times these are thrown in, the SNDA or NDA clauses are thrown in as boilerplate, so people don't really pay attention to them. But now what we've seen are tenants are insisting on these provisions or on these separate documents. So sometimes there'll be an SNDA reference in your lease. Sometimes you actually get a SNDA or an NDA, non-disturbance agreement, from your landlord. Okay, and tenants are now insisting on these, so you need to be aware of what they are, and you need to be aware of how to negotiate these. Okay, but basically this is a document that protects the tenant if there's any new landlord that comes into place. If the landlord's lender forecloses on that landlord, we want the ability to continue our lease, because based on the timing, based on who has prior rights with respect to the space, the lender's lease or the lender's loan may be able to wipe out your lease. You may lose everything if you're a tenant without an SNDA. Okay, you may lose the entire lease. And guess what? Now you got to go find somewhere else at your own expense. Okay, and so this document, the SNDA or the NDA, protects a tenant from those things happening, particularly if there's a foreclosure. Okay, it also protects a landlord if the landlord eventually wants to obtain financing. It'll help them out, because it basically means that the tenant is saying, I will agree to any new lender, I will agree to any new landlord, so long as my lease is protected. And so it's good for both parties to really have. And sometimes we can't get an SNDA or an NDA at or prior to lease execution. And so if we have something in the document, if we have something in the lease agreement that says we'll get one within a reasonable time after lease execution, that's fine as well. Okay, without an SNDA or an NDA, courts will interpret lease priority based on the timing of the documents. Okay, and so that's very, very important, right? That's the issue that's come up. What will happen is a lender may lose the ability to control that rent or to control that tenant if the lender has to come in, and that tenant may lose the ability to continue to rent out space without one of these documents. And so what we've seen courts now do is they're saying, we want to see this, we want it explicitly laid out. So what we're seeing is this trend of the courts now to really agree or to really interpret the parties' documents based on what's in there. And so it's very important to include that language in there. Okay, so we talked about force majeure, which really needs to be in there, really needs to be addressed. We talked about the issues that pop up, notice with force majeure, the event, what it allows me to do, how I provide notice, that those types of things. We talked about the use provision, all of which have been ruled upon recently by the courts. We've talked about the SNDA or NDA provision, which again is a very, very important document, protects our tenants, right? Mainly protects our tenants. Well, what about rent increases? What about this fourth issue? This is a big one right now, particularly because everything's getting more expensive. And so rent increases are addressed in most leases. We're talking about either the yearly rent increase, the year over year, hey, I've got to pay an extra 10% this year, or I've got to pay an extra 5% year over year, and that's just pegged in the lease, and there's just amounts that are put in the lease that I have to pay. But what about on renewal? So a lot of times on renewal, what will happen is that the rental rate will increase, and that rental rate is pegged by the consumer price index. Okay, so let's say we've got a 5-year lease and it expires at the end of October of 2022. We're going to give notice to the landlord that we're going to exercise the right to continue this 5-year lease or 3-year lease or whatever the term is. We want to continue it, and we have to figure out what that new rental rate is going to be. Well, again, a lot of times in those renewal or those option periods, it's pegged to the CPI. It's pegged to the consumer price index. Well, guess what? The consumer price index is the highest it's been in a very long time, maybe ever. And so we've got to protect our tenants in this situation, because what could happen is the tenant may be priced out of this deal because the CPI means that their rental rate is going to go up far more than they can actually afford. Okay, so if we're representing a tenant, the rents in the subsequent years could get very, very pricey. So maybe we don't use that consumer price index peg. Maybe we use a different way to calculate this. Maybe what we do is we go to 2 other brokers who come up with an opinion as to what the rent should be, and we use the average of those 2. That's usually what people prefer, especially now that the CPI is increasing. Okay, and so that's something that's very, very important. I don't have a court case on the CPI increases as of yet, but it's increasing, and tenants are getting priced out of some of these deals, and they're getting, having to leave certain space because it's just gotten so unaffordable based on that rental amount, based on that increase in rental amount that can happen in the option periods. Okay, so again, we talked about force majeure, we talked about use provisions, we talked about SNDAs, we talked about now we talked about this rent escalation. Those are probably the 4 or 5 of the big ones that I'm seeing. Okay, another one that gets litigated every once in a while is the security deposit. Okay, so we've got to address the security deposit in our lease, right? It makes sense. And under Arizona law, there's no cap on what a landlord can request in terms of a security deposit. That's only found in the residential context. The residential context, a landlord can only ask for 1.5 times the monthly rent, but in the commercial context, you can ask for much more. And so what happens sometimes is that a tenant will leave their space and they'll want to get their rent back or their security deposit back because it's a pretty high amount. It's more than 1.5 times what they've been paying in rent. It may be a large amount, 10,000, 20,000, 25,000, 35,000, whatever that may be. And so the landlord may play games about returning that security deposit. Oh, you left the carpet in bad shape. Oh, the tile's in bad shape. Oh, we had to charge you for removing some of your the things you install, those types of things. Well, it's very important, and a lot of people aren't including this, especially when the security deposit is particularly high. We want to give our tenants the right to request a pre-lease termination walkthrough. We want our landlord to tell us any problems that they see prior to the lease expiring, so that we have the opportunity to fix those. We have the opportunity to lock in our landlord to saying, hey, these are really the only issues that remain. Okay, and so then we have a much better shot at getting our entire security deposit back. Because what ends up happening is that sometimes the tenants get very, very frustrated. They'll contact an attorney, and our hands are a little bit tied because the security deposit has to be high enough that it makes it worth somebody spending the time and the money to go after the landlord. But they want that money, and sometimes the landlords will hold that up. And so what you ought to consider doing is asking for a pre-lease termination walkthrough, just like we do in the residential side. Most landlords will agree to this, and so it's something to include. Okay, another issue that we've seen come up recently is the holdover provision. Okay, this comes up usually in good leasing times like they are now. And the what holdover refers to is a tenant that sticks around after the termination of their lease. After their lease expires, the holdover provision kicks in and says, okay, we're not going to kick you out yet. You can stay here a little bit longer, but you have to pay this certain amount for rent. Okay, and so the holdover provision is an amount that kicks in at lease expiration, and a lot of times it's 150% of what the person or the tenant was previously paying. Sometimes it's 200%. And what we've seen recently is landlords forgetting to include a holdover provision or a holdover rent amount. Okay, And what is market right now is probably 150 to 200% of what the tenant was previously paying. So if there's no holdover provision and you're representing a landlord, your landlord's not going to be too happy. And so what we want to include is a confirmation of the surrender date. And we want to include a holdover provision that says you're going to have to pay 150% or 200% until one of us gives notice that we're not going to continue this. Okay, so it's very, very important to include a holdover provision to allow that tenant to stay in place, but to allow the landlord to collect an additional amount of rent. Okay, so that's another one that we've seen up. The other one that comes up quite often is leasing guarantees, right? And so let's say you've got a fairly new business, the tenant's a fairly new LLC, they just formed it this year, they don't really have a business track record. And so what a landlord is going to want in those situations is a personal guarantee from somebody else. Usually it's going to be one of the principals, one of the owners of that new entity, okay? And so a personal guarantee is usually going to be required by the landlord unless this tenant has a long track record of good rental history. And so these are permitted. You'll see a lease and a guarantee in these types of situations that's being required by the landlord. If you're representing a tenant in these situations, you want to try to get these limited or have them burn off, okay? And what I mean by that is you want them limited either in terms of duration. So, hey, look, we have a 10-year lease here for this space, but this is going to burn off. This is done after the first 2 years of me paying you timely rent, or this is done after the first 5 years, or what you have is a cap. This is the maximum exposure that you as the tenant or you as the guarantor are going to have for guaranteeing this lease. Maybe it's, you know, the first 2 years of rent. Maybe it's a capped amount of $25,000. Maybe it's $100,000. But if we're advocating for our tenant clients in these situations, we want to at least try to have a burn off or a maximum exposure for these folks, okay? Courts will interpret these very strictly as well, okay? Courts will allow you, if it's in the guarantee document, a lot of principals will say, well, you have to go after the tenant before you can go after me as the guarantor. And if it's in the guarantee document that says you don't have to do that, which most of them have, you don't have to go after them, courts will interpret it that way. You don't have to go after the person that's primarily obligated for the lease first. You don't have to do that. You can actually go after the guarantors first. You can go after both at the same time. And courts will allow that to happen. So we have to be very, very clear about how we want stuff to happen in that guarantee, okay? So again, it's important to include those provisions if it's important to your tenants. If they're being required to sign a guarantee, we want to limit the exposure, limit the negative consequences if something bad goes wrong, okay? So those, I would say, are the top provisions that, you know, are creating some you know, negotiation opportunities right now. Again, it's the force majeure clause, it's the use provision, it's the SNDAs or NDAs, it's the rent increases, particularly in light of the inflation that we've had. It's the security deposit, the guarantees, and then the holdover provisions. But that's not it. I mean, there's certainly a number of other provisions that are key right now that are important. But I would say those, you know, 7, 8, 9 are probably the most important that we've seen come up. We've also seen a couple of other issues that need to be addressed in all leases, one of which is parking. If you need extra parking, if you need covered parking, if you run the type of business that is going to need guaranteed spaces, you need to make sure that that's in your lease, because otherwise you're not going to get those guaranteed spaces, and you may have to pay for it, but most people are okay. Another provision that people are negotiating right now is the signage. You know, what can be included with my sign, with my banner sign, with whatever sign, what we're putting up with the building sign, whatever it is. You know, I need to know, you know, that you've approved my sign as the landlord. I need to know that you're okay with me putting it up, and I need to know the conditions under which I have to take it down. I need to know if I have to go to the zoning board with the city of Phoenix or city of Scottsdale or whatever it is to get this approved as well. Okay. And so signage is an important one. Parking and signage are very important. Another one that comes up is it's boilerplate, but now we really consider it, particularly after the last couple of years, is compliance with laws. Okay, so usually in most commercial leases, there's a boilerplate provision that says the tenant agrees to comply with all laws. Well, what does that mean? What does that mean if there's a government shutdown? Do we have to shut down? Do we have to comply with every single law? And if we don't comply, what happens? If we do comply, what happens? This is an event of force majeure. Okay. And so people are taking a look at this compliance with the laws provision a little bit closer now than they ever have been. Another one that pops up is assignment and subletting. If I need the ability to assign or sell my lease or get out of this lease, can I find another restaurant to come over and take over my space? Can I find somebody else to assign? Can I reorganize my business and become a different business and assign my rights in this lease to that new business, or to another restaurant owner, or to another office owner, another office space? What is the ability to do that? And assigning, when we're talking about an assignment, that is a conveyance of all lease rights. Okay. Whereas a sublease is something where the tenant conveys not the entire lease, the rights in the lease. Okay, so maybe it's a space that you can use, maybe it's a portion of the lease, but it's not the entire lease. So an assignment is a complete assignment. It's a complete conveyance of all of the tenant's lease rights. Whereas a sublease, you're not conveying every single right. You're conveying, hey, you get to use these offices, you get to use this place for the next 6 months, whereas the lease expires in 12 months. And so keep those things in mind. And a lot of times, landlords are going to require a pretty steep assignment or sublease fee, and they're going to want to make sure that you're paying them. They're going to want to make sure that they have the right to go in and collect if they need to. And they want to know who's coming into their building, because they want to know if that affects their tenant mix and any safety profile issues, those types of things. And so assignments and subleasing, if that's important to either your landlord tenant or your client or your tenant clients, make sure that stuff is definitely addressed. The other one that comes up right now is build out times. So if your landlord is doing some build out, some redoing of the premises, of the lease premises, of the lease space, it's taken forever now. And so what does that really mean for the commencement date of the lease? When do I really have to start paying rent? Is it when the lease is signed, which may be? Is it when the build out is complete and we have approvals from the city? We have a certificate of occupancy from the city. When does my rent obligation come due? And can I cancel if this build out is just taking too long? If I've got a business that needs to really be making money, what happens if the build out is taking too long? Okay, so that's an issue that's coming up that we've seen in a lot of commercial leases is what happens when the build out just takes too long. And then finally, the common area expenses, right? Common area caps. So common area expenses or common area maintenance expenses are things that you as the tenant may have to pay to keep the facility, to keep the commercial space, to keep it running, to mow the lawn, to mow the grass, to keep up the building, to all sorts of these maintenance issues, to keep the air conditioning in top order, right? So common area maintenance expenses are usually shared expenses by your tenants and by other tenants at a particular space. And these costs are going up as well. So as labor costs go up because they have to hire more landscapers, or the landscaper fees go up, or other painters and all sorts of these other things, what does that do with our CAM, our common area maintenance expenses? Well, as a landlord, you want the ability to pass through all CAM expenses, and you don't want there to be a cap. As a tenant, you want there to be a cap, because what you don't want to have is a situation that the CAM alone becomes much more unaffordable, and the space just becomes less attractive to you. And so what you want to do as a tenant anyways is have a cap. Try to say, look, CAM expenses cannot exceed 5% year over year, or these expenses are not included in CAM. And so you're backing out certain things. So I would say those are the top 15 or so provisions that we're trying to negotiate that have really been spurred on by some of the pandemic issues, that have really been spurred on by some of the labor shortage issues and the inflation issues. So again, those are the use provision, the force majeure, the SNDA, The rent increases, certainly that's a big one. Security deposit, those things need to be addressed. Holdover, guarantees, parking signage, and compliance with laws, assignment, subleasing, those types of things really need to be addressed. The build out time is a big one, and then the CAM expenses. And so if you need any provisions that sort of address these issues, or if you need a checklist, just let me know. I'm happy to get you those. Those are about 12 things that we negotiate and we look at. When we look at a lease, if somebody on the landlord side wants us to review a lease, or if somebody on the tenant side wants us to review a lease, we first start with the LOI, the letter of intent, or the term sheet, or the memorandum of understanding, or whatever the parties want to call it. This is a non-binding document that just says, hey, these are the parameters under which we may enter into a lease agreement at some point. Okay. So whenever I review a lease, my first step is to review the LOI and make sure all of the terms in the LOI or the term sheet or the memorandum, whatever you want to call it, are contained in the lease. It's a red flag if I don't see some of those issues, or if I don't see all of those issues that the parties have already agreed upon. This is the business terms. If I don't see those already in the lease, if my options to extend or my options to renew aren't in there, if the agreed upon rent isn't in there. So we want to make sure that all of the business terms, this is key for anybody representing a tenant, all of my business terms are contained in the lease. And then what I do is I go through a checklist and I make sure that I understand what is my tenant's business, what is my landlord's business, what are the things that are really important to them, based on this type of business, whether it's a restaurant, whether it's an office building, whether it's retail, warehouse, whatever it may be. What are the things that are going to be important? And then I've got checklists for each type of these deals, each type of tenant type, or each type of lease type. Again, warehouse, medical, retail, office, and restaurant. Those are the kind of the big ones. And so what I want to make sure is I'm including everything that either a tenant or a landlord needs in those situations. I don't want to wing it. I don't want to just rely on the LOI. I don't want to rely on just what the tenant is telling me. We want to make sure that we review the LOI and then we have a checklist for all of the things that need to be included for this type of tenant, for this type of tenant mix. Okay. So those are the things that we're seeing right now. Those are the things that you ought to be including in every lease. I know that some of you are using the form documents, and so some of the forms may need to be modified a little bit, and that's okay. You're allowed to do that. And if you need a checklist, or if you need any of these inserts or provisions, I'm happy to get those to you. I can get those over to WeServe, or you can email me separately. I'll put my email address in the chat. That way you have it, or you can give me a call. But I don't know if there's any questions. You're welcome to take yourselves off of mute, or shoot me a chat, and I'm happy to get those. If not, then I hope everybody has a great week.
All right. Does anybody have any questions for Patrick before we go? You can unmute yourself and ask those questions. Thank you, Jared. It's correct. Great information. That is true. All right. Well, if we don't have any questions for Patrick, then we're going to go ahead and let everybody go. Right. Oh, another great information. Yes. We appreciate that. All right, everyone. We will see you next time. Thank you, Patrick. We appreciate your time.
You bet, Lisa. Take care.
Thanks. You too. All righty. Bye-bye.